Let's again start on our tutorials. And now we're going to talk about ADRs. As usual, the Wentworth-Miller method. We're going to identify parties, objectives, premises, the elements, and the issues. So we're going to apply this now to the assignment. And we're going to focus on one area of flow for your assignment. So for the purposes of the assignment, you're going to be given two scenarios. And you're expected to write something around 400 plus 10% without penalty on each one of these scenarios. And please make sure that you don't write me an essay. This is not about writing an essay. You know, it's great to have an introduction and a body and a conclusion. But that's not what you're going to get marks for. You're going to get marks because you are going to be able to apply the Wentworth-Miller method, and you're going to use it to be able to identify what issues we have in this short scenario, and then propose a solution based on only one area of flow, which is alternative dispute resolution. Some of you sometimes go outside this framework and they say, but there is this act, you know, that says something about this kind of problem. For example, wearing safety belts, or, you know, there is this precedent that happened, you know, that could also be relevant here. And that's great, and you will get marks for it. But don't make that the end of your analysis. That's just the beginning. I need to make sure that you understand ADRs and you apply ADRs, and that's all you need for the assignment. Okay, what are ADRs? So we're talking about dispute resolution. One way of dispute resolution is litigation. I can end my dispute with you by taking you to court. However, that might actually be counterproductive. Not just because of the delays and the costs, but because it could be terminal to our relationship. As you know, when you go to court, especially in our country and common law countries originally, our legal system is adversarial, which means that when we go to court, we are really, you know, attacking each other. That's why we have developed things like family courts, for example, to make sure that when that happens, it's not actually going to end destroying the relationship between the parties. But there are also alternative dispute resolution methods other than going to court. That's what we want to talk about today for the purposes of your assignment. For every scenario, you need to identify two dispute resolution methods. So in total, you're going to have two for the first scenario, and you're going to have two for the second scenario. And it's important that you don't repeat the methods. So we expect you to end up discussing 4 different methods. If you believe that simply because of the way that you were assigned these scenarios, one method actually applies to both, you will have to tell us that I think that the same method applies to both, but I've already used it in the first scenario, so I'm going to use the next best alternative, which is this. You can't repeat the same method twice. All right. So we say there are these different dispute resolution methods. And why do we need them? Because of the delays, the costs, ignorance of the law, and sometimes intimidation, the fear that you get simply from being at court. Okay? Now, that doesn't mean that for your assignment, you cannot use litigation as one of the methods. It all depends on the scenario. And it's just like with your tests, online tests, you are assigned your scenarios randomly. So you are not all getting the same scenarios. you will get different scenarios depending on how they were assigned to you. There will be repetition, of course. Same thing with the quizzes. Every one of you is going to get a different set of questions, but of course some repetition as well. All right. So what are we talking about in relation to alternative dispute resolution? There are things like tribunals, like the QCAT, for example, or other tribunals, or the ombudsman. Okay. So this is basically an investigator. It's a Swedish word, investigator. And we're going to focus today on these ADRs, alternative dispute resolution methods. Now on page 60 of your textbook, you'll find this diagram. And the diagram basically gives us a snapshot of these alternatives to courts, including like tribunals and the ombudsman and industry schemes and so on. But we want to expand or unpack ADRs. And we're going to put them into 3 different buckets. The first one is what we call facilitative. Next is advisory. And the third is adjudicative. Under each one of these, we have our chopsticks. So you have 2 options under each one of these buckets. Either negotiation or mediation under facilitative, or conciliation or expert determination under advisory, or adjudication, commercial arbitration under adjudicative. Now remember, for the purposes of your assignment, you can also talk about litigation, if you think litigation is the way to go for your scenario. All right. Let's now go and discuss in some detail your required reading for the assignment. So this is the article, chapter 3, that you'll find in the resources that you need to read and you need to cite as the required reading for this assignment. Let's just go through it in some detail. So the first thing we want to know is, what is an ADR? And it shouldn't be surprising that we don't really have one definition for ADRs, just like law. It's a complex concept, so there are more definitions than one. But here's the one that's given by Astor and Chinkin in this chapter 3. It says ADR, because it's alternative, it's all forms of dispute resolution other than litigation, i.e. other than going to court. They say these are processes that leave the form and the content of the dispute, or the dispute resolution method rather, to the parties. Now we talked about the difference between common law and equity. And we said that equity came later so that it could remove the ossification or the rigidity that we found in the writs relating to common law. And that's the same thing that you see now in these ADRs compared to litigation. Litigation is very rigid. You have to follow specific procedures, including civil or criminal procedures of how you bring a case to court. You have no control over the outcome, and the judge really is the one that's going to run the show. Even though, of course, in adversarial systems, the parties or the counsels are also important in this process. If it's ADRs, however, these processes, what evidence you can admit, okay? Whether the outcome is going to be binding on us or not, okay? Who's going to be our arbiter? Who's going to be our umpire? Who's going to be our third party? We decide. You go to court, you can't choose the judge. You can't say, I want this one. So you have more control on the form and content of the dispute resolution. They are also defined as non-litigious processes with the intervention of a third party, i.e., there's no litigation, i.e., we're not going to court, but there's an intervention of a third party. The exception being one of the methods here. And we talked about that previously. Now you have 6 methods in front of you, and the article we're discussing introduces you to even more methods. That's fine. You can add to these methods as you see fit. But which one of these methods does not have a third party involved? Yeah, that's the one. What is it? I heard it. Someone here. No? Which one? You said it last time.
Conciliation.
It is?
Conciliation.
Conciliation. Okay. You see conciliation comes in which bucket? Under advisory. Yes? So what does that mean there? You are getting an advice. Where is the advice coming from? From the parties themselves? And that's someone else we call a third party. They give you an advice. It's not conciliation. Now, remember, in this diagram, the complexity or difficulty of these methods increases as you move from left to right, until you end up going with what was not shown here, which is litigation.
Why is litigation shown here?
Because these are alternative to litigation. So these are the alternatives.
So ADR. So are all these alternatives to litigation or just ADR?
ADR is an abbreviation for alternative dispute resolution. Alternative to what? Alternative to litigation. So all of these are alternatives to litigation. And the complexity and difficulty starts from simple on the left all the way to difficult on the right, until you hit litigation. So do you think a third party would be required when the method that you are using is simple? Maybe we can talk. We don't need to get someone else yet. And what do we call that?
Negotiation.
Negotiation. So keep it. Keep it. You can use negotiation as one of the methods of the ADRs that you're going to use for your assignment, even though this article says you need the intervention of a third party. Okay? There's always an exception to the rule. There's always an exception to the definition. This exception in this case is negotiation. Yes? All right. So we said there are 3 types of ADRs. These are the buckets we talked about. Either facilitative or advisory or adjudicative. But here they call it determinative. Why do they call it determinative? We'll see. What are these? So facilitative means that the parties are assisted and advised by the third party with respect to process. But the third party has no advisory or determinative role with respect to the outcome. What does that mean? The third party will give you advice on how to conduct our meetings, the protocol through which we're going to communicate. Okay? Whether we're going to have this as an open process, so public can know about what we are talking about, or it's a closed, private process. That's what we mean by the process. But this third party will have no power to tell us, as the parties, what the outcome of this method is going to be for us. We can accept or reject anything that ends up coming, at the end of the process. A proposition, a solution. Remember, when we talk about facilitative, there are only 2 types. This is your chopstick again. you can choose either negotiation or mediation. In this case, there's no third party in negotiation, but there's a third party in mediation, and the third party is called mediator. Let's look at a little bit more at mediation. So let's go and look at it on page 61. So let's just talk about these two first. These are the facilitative processes. Negotiation is the first. It involves voluntary and confidential discussions between the parties, either with or without a third party. So sometimes I would say actually it involves a third party. Usually it does not, but sometimes it could be of a complex nature to the point that you need someone to be there. And you see it in international diplomacy, for example, in civil wars. All right. This is what? To try to mutually resolve a dispute. The outcome generally remains confidential, and it will not have the same force of law as an award, i.e. an award coming, for example, through a court. So we can negotiate, and we might agree, but until we put that into writing, like for example, a sort of a contract or a sort of an agreement, it has no legal force. This is the simplest alternative dispute resolution to litigation. The next one up, still under this facilitative bucket, still under that category, is mediation. So like negotiation, it is voluntary and it's also confidential. But there's now an independent and neutral third party, what we call the mediator. This party, third party, assists the parties to try to find a way to resolve the dispute. If an outcome is reached, it can be kept confidential between the parties. It is not an adversarial process, i.e. compared to litigation. When would you use mediation? It's particularly useful in complex matters, where the parties may have ongoing contact. We don't want to end the relationship. And or the dispute involves mutual parties, because the parties, with the assistance of the mediator, may find a solution that's satisfactory to all parties. However, the mediator cannot impose a decision upon the parties. So they're going to be in charge of the process, but not in charge of the outcome. Thus, mediation can be implemented prior to or at the same time as other forms of dispute resolution, such as arbitration or litigation. And sometimes you go to court and the court says, no, start from mediation. They take you back. Okay? And sometimes you might sign a contract and you're not aware of it, but surprise, surprise, in that contract there's an arbitration clause. You're not happy with the contract, you say breach of contract, I want to sue you, you go to court, but then they say, but there's an arbitration clause here. What does the arbitration clause say? It says you can't go to court. You have first to go to arbitration. Okay? So that's really the trend today. We want to start with the ADRs. If these don't work, we go to trial. So complex matters and can be implemented in conjunction with other processes. mediation is being increasingly used in commercial, non-commercial, and non-criminal matters by the courts to try to reach settlements quickly and cheaply. So that's the same idea. You go to court, they bounce you back. It is also used by telecommunications industry ombudsman to try to resolve telecommunications disputes. So if this fails, if mediation fails, the parties may then turn to more complex methods such as arbitration or even litigation to resolve their dispute. All right. Okay. So let's then go back to our reading. We looked at the facilitative processes. So we said the parties are assisted by this third party with respect to the process, but not the outcome. Then you come to the next category, more advanced or more complex, more formal. So there's the third party again, but now the third party offers advice as to the facts of the dispute. So there's complexity in relation to these facts. So you need someone to be able to, sieve through the facts and say that this is actually what's fact and this is what's fiction. Once we agree on the facts, we can solve our problem. Some instances, under advisory as well, your third party can also advise on an appropriate outcome. So there are again two different methods under advisory, and these are conciliation and expert determination. Remember, in this category, there's an issue around the facts. So you need someone to advise you on the facts. It could either be the conciliator. Okay? So while the terms mediation and conciliation are used interchangeably, there are different processes because of the role of the third party. Okay? The third parties, the parties rather to a dispute, again with the assistance of a neutral third party, the conciliator, will identify the dispute, develop options, determine alternatives, and reach an agreement. So again, the conciliator is going to play the role of an advisor on the content of the dispute and suggest options and possible solutions. So the difference between the conciliator and the mediator is that the conciliator has more control on the process and possibly on the outcome. How is that different from expert determination? Again, it's under advisory. So the expert is going to advise, just like a conciliator. So why the difference? So expert determination is a process that provides for an independent expert to be appointed by the parties to give a determination on some dispute point of fact or law. Again, advisory process. And why would you need it? It's effective in settling disputes that are simple in content. For example, what's an acceptable trade or industry practice? Or something that's technical in nature. So when you get to your scenarios, keep that in mind. So what does this expert does? Okay, they are going to adopt processes or procedures suitable for obtaining information, give each party a reasonable opportunity to put their case, and deal with that of the opposing party. So this independent expert is not an arbitrator, not yet. So we're going to get to the determinative. Okay, and the parties will decide beforehand whether the determination is to be final and binding or not. If it is binding and final, it may form the basis for negotiation of a settlement or at least clarifying the issues. Okay.
Wait. Right, is that you're saying if expert determination is that it may form the basis for negotiation?
So it might sound surprising, but yes, we could start with this expert appraisal. Once we get the facts, we know what the parties have done, we can go back and start negotiating. Because what do you need to negotiate? What is it that you need to negotiate around or about? It's the facts. So if I don't have the facts, I can't start negotiation. Once we have agreed that this is what happened, these are the facts, where did you get them? From the expert determination. Once the expert gives us the facts, we can go back and do the negotiation. Yes? But did you follow what I just said to you? You can start from expert determination. So, for the purposes of your assignment, it's okay to say, I want to start with expert determination as my first ADR for this scenario, and then I want to go to negotiation. Because I need to get that first and then get the facts and go and do my negotiation. It doesn't have to be that you start with something simple, like negotiation, and then go to something more complex. It depends on the issues. We're going to apply these, and you'll see what I mean by that. Let's move on quickly to the last two, which are the determinative processes. Now, we said in our determinative processes that there are two, and we said that our reading says determinative processes are the same thing as adjudicative processes. This is where the third party makes a determination on the outcome of the dispute that's binding in the sense that's potentially legally enforceable. We're getting very close now to litigation. It's legally enforceable. All right, what do we have here? So we have these determinative processes, and we have adjudication and commercial arbitration. Okay. Now this came under acts by state governments. Okay. Building and construction industry security of payment legislation, and it establishes adjudication as a process to ensure payment to work. Now you can see that I'm talking about something very specific, building and construction industry. Again, the adjudicator is appointed under the relevant legislation or is chosen by the parties. Adjudication is carried out on the basis of the documents that the parties submit, although the adjudicator can call a conference, so just like a trial, and will then make a determination as to the amount of money that the respondent must pay to the claimants. In Queensland has also this adjudication process in place under another act called the Body Corporate and Community Management Act. So body corporate in relation to buildings, to assist lot owners in bodies corporate, like buildings, to resolve disputes. In comparison, you have commercial arbitration. Okay? It's a consensual process. So note that I've been talking about consensual processes all the way, as opposed to litigation, which is not consensual. If someone files a lawsuit against you, you have to go. Okay? You have to represent yourself. Here it says, once the arbitrator has made a decision, the rights of the parties that were in dispute are ended and then replaced by the arbitrator's award. So you can see that you don't have control anymore on the outcome of this process. All the states and territories have enacted essentially uniform domestic commercial arbitration acts, including the Commonwealth one. So what does it involve? It involves the hearing of a dispute by an independent arbitrator. This arbitrator is chosen by the parties and is someone who has some professional or technical background relevant to the dispute. On appointment, they usually call something called preliminary conference, where they agree on how they are going to conduct this process of arbitration. Now you'll find that when we conduct arbitration, we have to borrow from some of the things we do in litigation. So the first thing we talk about is something called natural justice. principles of natural justice. And what does that mean? So all parties are treated equally and fairly. You can see now that this is really a formal process. You have to follow certain procedures. You have to make sure that everyone is treated equally and fairly. Does that mean that you don't have to follow equally and fairly when you are negotiating, for example? No, it doesn't. But it means that when you come to this kind of process, it becomes something outside your control. So if that's not followed, you can actually challenge the outcome from this process through something similar, for example, judicial review. Okay? Again, at the end of the hearing, the arbitrator will make an award unless, so that's the default, unless you decide contrary to that, so you'd say that we don't actually to be bound by that. The award is going to be final and binding unless you decide otherwise. Okay? Most important thing again is that this really connects to the next level where you can go and challenge the award. It is final and binding, but just like in court, when you are not happy with the decision and you can challenge the decision based on a point of law, and the court gives you leave to appeal, you can actually take the same thing with arbitration. Okay. Let's then continue with our article. The article gives you a different classification of ADRs. So they talk about primary dispute resolution methods, such as negotiation, mediation, or adjudication, or hybrid methods, okay, that combine different methods from the primary category. So you could say, for example, in your answer to your assignment, in your first scenario, let's say, that I would like a hybrid dispute resolution process where, for example, we can start with, mediation, and then we can go on to do something like arbitration. Most important thing is not to just tell me what you think, it's why. Okay? The most important thing in your answers, or the critical skill we're trying to develop here, is to say why. Why do you think that's the best outcome, or these are the best two methods? So again, in terms of the facilitative category, we have negotiation. It does not usually involve a third party. We have mediation. It includes a third party, and the third party is going to isolate the issues, develop the options for a consensual settlement. It's not adversarial. And the mediator has no advisory role, especially on the outcome. Then we have advisory. This is just a summary from your article. Conciliation, just like mediation, but here the conciliator has an advisory role to the outcome. Conciliator has specialist knowledge and expertise in the subject matter. The expert determination, here the third party, i.e. the expert, carries out an independent investigation. The third party has an investigatory, inquisitorial role as an expert, but not as an arbitrator. They make no recommendations as to the outcomes. The last category is what's known as determinative or adjudicative, and you have arbitration, where the adversary process that's externally enforceable. So now you start seeing that we are moving more and more from consensual to adversarial, just like when we end with litigation. However, unlike litigation, arbitration is a private process. If you go to court, you cannot stop people from coming, and unless sometimes, of course, you can, but generally, people, the public, cannot come and listen. In arbitration, in courts, they will come and listen, okay? Like the press or the media. But the arbitration is private, so they can't actually listen to what you're saying. The awards are binding upon the parties. There's uniform legislation in Australia in relation to arbitration, and there are appeals, but they are limited. Finally, you have adjudication, again adversary process, externally enforceable, generally in relation to building and construction industry, and developed to stop contractors delaying payments or reducing payments. So, in a nutshell, we can look at these 6 different ADRs as follows. Plus litigation, yeah? So the first one is about whether there's a third party involved. Most of them have third parties except the negotiation, which is sometimes without a third party, usually without a third party. Is it voluntary? Most of them are voluntary except litigation. Are they confidential? Most of them are confidential except litigation. Litigation is not alternative, right? But I'm putting it there because I expect you still to look at it as part of your assignment. Adversarial. The adversarial ones are the ones at the end. These are the adjudicative processes. And then third party can impose decision. Negotiation, there's no third party. But the other 3, mediation, conciliation, expert determination, the third party cannot impose a decision. And the last 3, they can. Yes, someone online? Ready? Anyone wants to say something? All right, if not, I'm going to mute you for now. All right? Okay. We'll then continue with our ADR. So this is, of course, a tutorial, but we did this part of it as part of theory. Now, do you want to have another break for 10 minutes and then we come back and finish off on this example, or you want to just keep going? Keep going? Keep going. Let's then now apply what we have done, what we have learned. Let's look at one of the scenarios, or very similar to the scenarios that you will get in your assignments. If you get this particular scenario, please let me know, because I'm going to instruct markers not to mark this scenario. So if you get it by mistake, if it's assigned to you randomly, let me know. I'll replace it for you. Don't go through this again, because it's not fair to someone who did not get this scenario. All right. 2 large oil conglomerates are accusing each other of forming cartels to try to gain an advantage over the other. So this is your scenario. This is the one that you cut and paste into your template. In many other areas, they cooperate well to run their businesses, for example, delivery of fuel and so on. They need to resolve the dispute quickly to avoid a consumer backlash that they might not be able to control. 3 sentences, 3 sentences. This is a baby or mini problem-solving question. Not very different from the questions that you will get in part B of the exam. But that, of course, is not going to have 3 sentences. It's going to have paragraphs. Okay? So we're starting you off on something very simple, only 3 sentences. But we'll have to go through exactly the same process that we will do for the big questions. So, Wentworth-Miller method. So, can someone, for example, start us off on the parties? Anyone wants to contribute who the parties are in this case? If this goes to court, who would be the movement? Who takes whom to court? The 2 oil companies. It could be company 1 against company 2, or company 2 against company 1. What are their objectives? What do these companies do? What do these companies want? Go to court for what? Okay, so the objective, that what they want is to stop forming the cartels. Why? Why would you stop forming the cartels? What is the harm?
Influence their income.
Okay, so someone says it will influence their income, it will influence their revenue, it will influence their market share. So what do they want? If it's company 1 that takes company 2 to court, they want to show that company 2 is involved in these cartel practices, which means that you need to compensate me for the loss of market I've suffered because of that antitrust, they call it in the States, or cartel behavior. So far, so good? What are the premises? What's the legal theory or legal premise that you're going to use to take them to court? Let's just say that company 1 takes company 2 to court. What's the legal premise? We haven't studied it, yes? But what is it that they are going to complain about?
About the whole cartels.
Cartels. So they're going to invoke something that says cartels are illegal. Do you know what legislation would do that? If you are online, would you be able to just Google something like cartel and Australia? Would you be able to tell us which actually act prohibits cartels? See, you don't have to study, you just need to know how to fish for the information. Can anyone find for us what act prohibits cartels? Okay. In your own time, you'll come to an act called the Competition and Consumer Protection Act. So it protects competition against things like cartel, and it protects consumers. Competition and Consumer Act of 2010. This is an important act for us because Schedule 2 of this act is what's known as the Australian Consumer Law, which now has a lot of overlap with contracts and with torts and with criminal law. So that's the premise. What are the issues? Of course, here, they are not really legal issues in the sense that they are relating to jurisprudence or legal theory, but they relate to which method or two methods you're going to use to try and resolve this conflict without going to court. Or you can go to court if you think that's the only thing that you can do. So litigation is still possible. Sometimes some of you, which is perfectly fine, will simply say, I wouldn't go to litigation. My first advice here is not to go to courts. And this is why. That's your first method. So even though you are not recommending this method, that's fine, because now you show me why you don't want to do it. So that's enough for understanding. Yes? So it doesn't have to be a recommendation of two methods. You could simply say, here I will not recommend litigation, this is why, and then I will recommend one of the ADRs. Or you could say, I will recommend one of the ADRs, and then I will recommend litigation. Or you could just simply say, forget litigation, only two ADRs. All are good. What's important is not what you recommend, it's why. So what are the issues here? So everything that's given to you in this mini scenario is for a reason. 3 sentences. The first one says, 2 large oil conglomerates are accusing each other of forming cartels to try to gain an advantage over the other. That tells you who the parties are, what the premises are. Tick. In many other areas, they cooperate. They cooperate well to run their businesses, such as the delivery of fuels. What is that? Is that an issue? What is an issue?
But they're accusing each other.
Issue, we said, is about what? Tension. Is there a tension here between the cartel business, the accusations around cartel, and the fact that they are cooperating? You see tension now? What is the tension?
They're accusing each other of something that might not be true.
So you want to have the relationship, but you cannot have the relationship. You want to have trust, but you cannot have trust. I want to cooperate, but I'm afraid you are cutting me off as far as business or market share is concerned. Do you see the tension? What else? That's our second sentence. The last one, they need to resolve the dispute quickly to avoid a consumer backlash that they might not be able to control. Is there an issue here? What is the issue? Where's the tension? I want to accuse you, I'm company one, I want to accuse you of this cartel formation. I want my compensation. But again, I'm afraid that if I do so, I will lose even more market share because of consumer backlash. I think I'm losing market share. Okay, I come after you, and I lose even more market share. Unless what? I do it quickly. Yes? So, do you know now what the parties are? Do you know what their objectives are? And do you know what the issues are? Two issues. All of that I really want you to put in your first paragraph in the answer for your assignment.
So wait, could you repeat those?
Yeah. This is our Wentworth-Miller method. That's the only thing I will ever throw at you until we finish this course. Wentworth-Miller, Wentworth-Miller, Wentworth-Miller. Every time you see something, even if it's not legal, always look at the parties to the tension. What are their objectives? And what are the issues? Because here, for the purpose of your assignment, the issues will decide which ADR or litigation you're going to use. In the first paragraph, you should say something about the parties, who the parties are. Not that they are going to court, but that they are in tension. Then you talk about their objectives. Then you talk about the issues between these parties. And maybe even a little bit about the premise. Some of you, as I said, can sometimes go and say, oh, actually cartels are governed by this act, or, oh, we know that this is something that there was this famous case about, and so on and so forth. That's all in the first paragraph. In the second paragraph, you're going to start talking about the first ADR or litigation or negation of litigation. So you want to say, I don't want to use litigation in the second paragraph. So you start the second paragraph by identifying which ADR you're going to use, or if it's litigation, or if it's not litigation. And the same thing in the third paragraph, the second method, and then very brief conclusion at the end. 400 words. You can go up to 400 plus 10%, 440. Okay, so it's the same thing here. You identify the parties, the objectives of these parties, the premises. In this case, there are not as much elements, but I will show you what we mean by that in terms of ADRs. So far, so good? No? Okay. We'll look at that a bit more. Yes?
So are the second and third paragraphs both supposed to have ADR methods, different methods?
Yeah. So if you go to your assignment details, and the assignment details are available online. So if we go to Study Desk, okay, let's go to this page actually, assessment, and you'll find that you have the written assignment details and the assignment template. The assignment template is the one where you would cut and paste your scenarios, but you also have this detailed information about what you need to do for the assignment. So it's a Word doc. And it starts by saying reading. So one of them is basically this study desk critical thinking. And then the Astor and Chinkin chapter that we've just summarized together. And then it gives you an introduction of what you need to do for the assignment, and it talks about that the first thing you want to do is to choose. So you will be given 2 scenarios, right? You will be given 2 scenarios, and for each scenario you are required to 1. Choose 2 dispute resolution methods for each of your scenarios from the following list. Okay, some of these are described in the Astor and Chinkin reading and giving reasons relating to the advantages found in your research. State which might be preferred for each particular scenario. So this example we just looked at is your first scenario. For this scenario, excuse me, we said you're going to summarize the scenario plus the parties and the objectives and the issues in the first paragraph. In your second paragraph, you will choose one of these methods. Now there's case presentation, and I haven't covered case presentation. So you might want to use it if you want to, but you will have to do some research. You don't have to use it. And something is also missing from this list, and I said that you can already use it. What's that thing that's missing? Negotiation. Thank you. Okay. But remember, you can use litigation also in the negative, as if you're going to say, I actually recommend against it. So that answers your question. First paragraph is the summary. Second paragraph, first method. Third paragraph, second method, and you conclude. 4 paragraphs maximum. Now, do you have to follow the structure? No, you don't. So I'm just giving you a recommendation to help you and help the markers. Now, if you want to do something different, and I love to be creative, that's fine. Yeah? Do whatever you want. But don't write me an essay. Don't go and say, oh, let's just pluck the first one, litigation, advantage of litigation, or in the abstract. Advantage of litigation, disadvantage of litigation, and then I'm going to choose the next one. Advantage of mediation, disadvantage of mediation, and I'm done. You will fail the assignment unless you relate everything you say to the scenario. It's not an essay. It's a problem-solving question. You need to relate everything to the scenario. Why litigation? Why mediation? So you have to use the facts. You have to take these 3 sentences and use them in your argument why I want to use litigation. So let's look at that in some more detail right now. So, who can recommend the first ADR or litigation for that matter? Which one do you think would be the best? How do you go about thinking about that?
A non-adversarial one. So that you
Perfect. So you start from the big categories. We said you have what? The first one was what? Facilitative. And then the second one, advisory. Third one, determinative. So you're saying you want to use something that's not adversarial. Why is that?
They get along well together usually.
So there's an issue, and that issue decides where you go. The issue here is that they want to talk about cartels, and they have this problem between each other, but it's just part of their business. They want to make sure that they maintain what? Cooperation, because they deliver fuel and other things. So whatever you recommend, it better be something that is non-adversarial. Why not non-adversarial? If it's adversarial, it's going to destroy the relationship, which means what? Which means they cannot continue cooperating. And how is that going to affect their market share? Have you actually solved their problem?
Made it worse.
You made it worse. Great. So what's your name again?
Oh, Ryan.
Ryan. So Ryan told us, let's go for something non-adversarial. Great. What? Like what?
Mediation or something.
So how do you go about doing that? So let's see, just from what you told us now, what we can exclude. a process of elimination. Which bucket or category you can just eliminate right now because we know we don't want something adversarial.
Adjudicative.
Adjudicative. So you're left, you had 6, now you have only 4. Facilitative and advisory. You happy with that? So we used one issue, the issue of cooperation. We took out 2. What is the next issue we could use? This is how you use the issues. The other issue, you want to resolve the dispute quickly, right? We said that's the issue. You want to go and talk about cartel, but you want to do it quickly. What else other than quickly you can infer from the facts? Infer. It's not given to you, but because of what's given to you, you would say, oh, yeah, quickly, but there's also something else that you need to do. Privately. Why is it privately?
Because they don't want to consumer backlash, so I'm guessing they want to keep this as secret as they possibly can.
Did I tell you that?
No,
But you have to infer. Not assume, infer. Quickly and privately. What now? You want something that's quick and that's private. Again, if I want something that's private, forget the first assumption, the first issue. Out of these 3 buckets, out of these 3 categories, which one I can eliminate because I want something that is private?
Advisory.
Advisory is not private. We said facilitative is not private. When you negotiate, you think that the press is going to have to come in, like the courts. What about adjudicative? Is that private? No? No? We just looked at it.
All private.
Except what?
Well,
Litigation. So that piece by itself is not going to help you eliminate any of these. But I want you to talk about it. What about quickly then? Which one do you think is the quickest here?
negotiation.
The simplest, which is negotiation. It's the easiest. Is that good enough?
Probably.
Where is the third issue now? We solved the issue of cooperation. We looked at the issue of privately. And now we're looking at quickly. But you have to balance quickly with the third issue, which is what? What are they trying to figure out? What are they looking for?
See if the others are cartel.
They are looking for what? Facts. What facts?
If it's true.
What is true?
Cartel.
Cartel. Yes, they are trying to ascertain whether company 2 is involved in cartel-like behavior. And not only that, if you find that out, what were the consequences? What was the harm? How much market share was affected? Yes?
So they need expert determination.
So, what's your name?
Yeah.
Tim. So Tim says, I want to do it quickly. Yes, but, so quickly here maybe would make sure that you don't go to the right. So no litigation, you know. You want to be somewhere here. But how much here? What you need is someone who can ascertain the facts on cartel behavior. And what kind of a person would that be? An expert. Someone who's going to be able to have an inquisitorial role. Inquisitorial role. I will ask you questions and interrogate you and get witnesses and look at accounts and look at transactions. Then you can ascertain whether there's cartel behavior or not. So what he did is to go and say, you need an advisor to advise me whether there's cartel behavior or not. Is it going to be a conciliator or an expert? You need the expert because here it's a more technical matter and you need someone to go and investigate. Conciliator is not going to investigate for you. You present him with the facts and that's it. The expert can have an inquisitorial role. He will go beyond what you give him to find the truth, to find the facts. Do we know what our first ADR is? Did we find our first ADR? What is it called?
Expert determination.
Expert determination. So you would say your first sentence in the second paragraph, the first ADR I'd like to recommend is expert determination. Expert determination is going to allow the parties to resolve their to resolve their. I'll take that back. You can start by saying I can eliminate adjudicative processes, okay, because I need to make sure that this is going to be a non-adversarial process. I'm now left with facilitative and advisory processes. I would like to look at advisory processes because the problem for the parties is to ascertain whether there in fact was any cartel behavior or not. But because it's a complex matter that might need inquisitorial, role, I will have to use expert determination. Then you say something about expert determination. Expert determination would allow them the quick resolution, would allow them the private resolution, see, and come to an understanding of whether in fact there was cartel behavior or not. And that's it. So advantages, disadvantages, not an abstract, always back to the facts in the scenario. What is the third paragraph? Now we're done with our first ADR. What is the next ADR? Based on the first recommendation of expert determination. The expert comes back and says, here are the facts. There was, in fact, cartel behavior, and here is the evidence, and this is how much it affected company one. What next?
Would you take a litigation then? You would take when it resolves? Well,
No. No. So now you come up with these facts, okay? This is an expert, an independent expert. What happens after that? What do you want to do now? What would be the most important next step now? To do what? Say it louder, please.
Negotiate.
Negotiate. Do you agree? Why didn't you start by negotiating? Why do you agree, first of all, that you go back to the simplest method?
Well, because now you know the truth. Like before you didn't know the truth, but now that the expert has gone in and looked through it, he does know the truth, and now you know everything.
I can negotiate around that.
Well, now you can negotiate with each other truthfully. One of you is just lying now. Well, one of you could still.
Are you surprised that you had to start here and come down there? You shouldn't be. Because what you want is the simplest, the quickest, the cheapest. But sometimes that doesn't work. So whatever is missing, and then you can always go back and negotiate. Any questions? So now you got your first paragraph, your second paragraph, and your third paragraph. Again, when you say you negotiate, you say, what is negotiation? It's always good to define what negotiation is. Don't feel, don't be prohibited from citing the textbook. That's fine. Always cite the textbook. If you don't know how, go online or even ask the librarians. Okay? And then the last thing that you want to do is the conclusion. What are you going to say in the conclusion? In conclusion, I have recommended first expert determination because we lack these facts, and then I recommended negotiation because I now can go and do it quickly and privately and hopefully come to a conclusion based on those facts. And you're done. But why are you going to score full marks on such an answer? Why? What am I looking for? Remember, this is not an essay. This is a problem-solving question. We're looking at your analytical skills. What do I mean by analytical skills? What do I mean by critical skills?
You are looking at how we are able to read a scenario and judge a scenario based on what's been written.
And that's something, correct? And that's something you have not done before. Not in any other course are you going to take something like a question and use that question to answer in the sense that we do it here. If you don't refer to the question, if you simply write an essay, just talking about any methods you like and just giving me abstract advantages and disadvantages, copying from this book or something online, you know where you're going. You're going to get a C for conclusory. I'm not looking for a conclusion. I don't even care about the conclusion. I want to see the why. So every time someone's reading what you're writing, they're going, why? Negotiation, why? Yeah, why? How is that related to what I told you in the scenario? What is the issue you're trying to solve? Why? Why? And hopefully by the end of this course, that's the first thing you will always ask people when they propose anything to you. Always go after the why. The why explains a lot of whether you are going to accept what they are proposing or not. And we'll leave it here unless you have any other questions. We're going to take some more. So we said that we're going to look something like company 1 and company 2. Okay? They both want to investigate whether there are cartels, but the problem with the tension here that they want to continue to cooperate and they want to resolve this quickly. We said that both companies suggest there are cartels. Again, what dispute methods would best answer this concern? Look at the characteristics of the required third party. What kind of third party do you need in order for you to resolve the issues we've identified, namely the issue of cartels and the lack of facts, the issue of cooperation, and the issue of resolving this quickly and privately? And Tim has a question for us.
I just have a question. In another case that was kind of similar to this one between Apple and Samsung a few years ago, why would they have turned that into a public thing? Would that be to harm a brand reputation or something like that, or why would that have
They
gone
didn't
so
turn
public?
it. They didn't turn it into public. But let me ask you this question.
Well, isn't it also bad that there's such big companies that something like that would go public?
Yeah, that's a good argument. But let me ask you this question. What do you know about the history between these two companies?
Well, Apple buy a lot of their hardware from Samsung. They manufacture their screens and a lot of their hardware, so they should have a good relationship
Yeah.
that way.
But what happened before them? We're talking about which case?
Well, just the big case where Apple were accusing Samsung of copying their phone.
Okay. So my question to you, was that the first time? My proposition is that there's history between these companies. And if you go back to it, you'll find that that's what Steve Jobs used to do all the time.
Steve Jobs wasn't a very good person.
So Steve Jobs went after Bill Gates.
Well, yeah, because didn't Bill Gates invent some computer program that was almost identical to something Steve Jobs was creating?
The issue there was Windows. Whether the idea of Windows, i.e. the graphic interface, was something that Steve Jobs came with or Bill Gates. But my point to you is that this was not, my interpretation, might not have been the first time, and that's why the press already knows about this. So, look, let me just say this at the very end. All what I'm talking to you here is just part of a toolbox. You are mostly business students, and I'm sure that you're going to take economic courses. Economics? And part of economics, and I can't emphasize that enough, is called game theory. And the idea of game theory is that you have to use everything that's at your disposal to win. Sometimes putting public pressure, I could actually leak the information. I would leak the information to put public pressure on you. I could even try to have a war waged against North Korea to put public pressure on you. It's game theory.
Because
Pretty
public,
extreme.
Yes?
Nationalities as well, so it's like self-free.
yeah.
So that's why it becomes public.
Anything else you'd like to add?
Yeah, well, I was just going to say that these days brand image is really like the highest thing for a company for market share, and so by harming their brand image, that's war.
But that's the thing. You see, Apple has a religious following. Apple is not a company. Apple is a cult.
Yeah, that's right.
It is.
Apple is something that identifies you as a status symbol,
Yeah.
not a company anymore. And you'll find that many people would choose Apple knowing that maybe the product that they are using is not as good as the one that Samsung is providing. See? So those things will also come into consideration, whether you want to go public or not. Maybe Apple thinks that they will get sympathy out of actually going public with this thing.
Yeah.
So that has nothing to do with the law in the sense of ADRs, but it has to do a lot with something called game theory. We're not going to teach game theory here, but if you come to a course called Eco 3033, which is about law and economics, we interpret why the law evolves the way it does, why people decide the way they do, based on these economic tools such as game theory. Leave it here. I'll see you next week. Thank you. Timing.